having studied the detail of the extensive documentation, I could not say that the Duke's sense of grievance translated into a legal argument for the challenge to Ravek's decision. The legal question, indeed the only question for the court, was whether Sir Richard had failed to follow Ravek's policy without a good reason. From the Duke of Sussex's point of view, I said that something may indeed have gone wrong, in that an unintended consequence of his decision to step back from royal duties and spend the majority of his time abroad has been that he's been provided with a more bespoke and generally lesser level of protection than what he was provided with in the UK before. But that did not of itself give rise to a legal complaint. Did Sir Richard fail to follow Ravek's policy without a good reason? I said in my judgment that Sir Richard had indeed failed to follow Ravek's policy, but I said that there were four main reasons for holding as a matter of law that Sir Richard had had a good reason for having done so. First, Ravek's policy was inward-facing and unpublished, and it concerned an area of national importance that was peculiarly within the expertise of law enforcement agencies, Ravek, and the royal household. Secondly, in this area of high political sensitivity, the court had considerable respect for Sir Richard and Ravek as decision makers, because they had unrivaled expertise and experience in the field of royal protection. Thirdly, the decision was explained in contemporaneous documentation to the effect that the Risk Management Board would not undertake further risk analyses for the Duke of Sussex because they were no longer required, given the alternative governance arrangements that were to be established on a case-by-case basis for the future. Sir Richard had, however, obtained 3 threat assessments for the Duke of Sussex during February 2020 before writing the decision letter. Fourthly, Sir Richard and Ravek had given compelling reasons for having reached the conclusion that the appropriate course was to establish bespoke arrangements for when the Duke returned to the United Kingdom on future visits. The Duke was in effect stepping in and out of the cohort of protection provided by Ravek. Outside the UK, he was outside the cohort, but when in the UK, his security would be considered as appropriate depending on the circumstances. It was impossible, I said in my judgment, to say that this reasoning was illogical or inappropriate. Indeed, it seemed sensible. Finally, even if there had been a risk analysis from the Risk Management Board, it would, very likely, have only confirmed the threat, vulnerability, and impact levels which the Duke had faced when earlier risk analyses were undertaken. But it would have had nothing to say on the critical features of the changed situation, which were the need for protective security on future uncertain visits and the government's appetite for risk. The decisions taken in the decision letter and subsequently were taken, I said in my judgment, as an understandable and perhaps predictable reaction to the Duke of Sussex having stepped back from royal duties and having left the UK to live principally overseas. So the conclusion, in my judgment, with which my colleagues, Lord Justices Bean and Edis, agreed was that the Duke of Sussex's appeal would be dismissed. So that concludes this afternoon's hearing. Thank you.